After that, we have this part which talks about return of plaint, where we have 3 rules mentioned. Okay, there are 3 rules mentioned in this part as well, return of plaint. So the first rule talks about return of plaint in itself. It says that the plaint shall at any stage of the suit be returned to be presented to the court in which the suit should have been instituted. At any, if the court, right, where the suit is being instituted feels that we are not the right court having jurisdiction to try this matter, in such case, court may send that this certain plaint, we are returning it. We are not the right court to decide this matter, but it has to be filed in so and so court only because it falls under their jurisdiction. When court has decided that we need to return this certain plaint, what they need to do is the judge of the court who is taking this decision, right, passing this order that this plaint needs to be returned to so and so court, he shall endorse thereon. He would put his signature, plus he will mention some details in the over there itself when he takes this decision that we need to like return this plaint because we are not the right court having jurisdiction. So he will put his signature. He will mention the date on which the suit was presented before him. It might happen that on the first day itself, that decision was not taken that it has to be returned. So whenever the suit was presented, that date, whenever it was returned, that date also has to be mentioned. Who is presenting the case? Name of the party presenting it should be mentioned, and a brief statement of the reason. Why is the case being returned to this other court? That needs to be mentioned. All those details would be mentioned, and the judge would put his signature, who has given this order for return of the plaint. But now when he is returning the plaint, okay, if the case was filed in this court and the court decided that we are not the right court having jurisdiction, let's return it. What are the rules or process that they need to follow? So if the court has decided that, okay, we are not the right court having jurisdiction, we need to return it, that thing needs to be informed to the plaintiff. So court will inform to the plaintiff that, yes, you had filed this plaint and we are returning it because we don't have jurisdiction. And once plaintiff has been informed, plaintiff has the option of filing an application before court. Plaintiff can submit an application before that court and request for certain things. That is specifying the court in which he proposes the proposes to present the plaint. If there are like options available for him and he wants that this certain plaint should be addressed to this certain court, he can mention a request by way of an application. He can mention that also, that out of these options, I want the case to be presented in so and so court only. Praying that the court may fix a date for appearance. He may also mention that please also specify a date. Along with that, also specify a date for appearance of parties in that certain court. Okay, and requesting notice of the date so fixed to the defendant. So plaintiff may say that it would be really great if you can fix 15th of February 2022 as the date of appearance. And also you inform the defendant about it. This is the date when you need to appear before that new court, right? So plaintiff would request for all these things. So where an application is made by the plaintiff that requesting for all these things, then before returning the plaint and notwithstanding the order for return of plaint was made by it on the ground that it has no jurisdiction to try the suit, if the plaintiff has submitted an application and requested for these things before the court, who has taken the decision of returning the plaint, court would try to fix, Okay, try to fix a date for appearance. And this is the date that we are fixing for appearance. Plus, also defendants would be informed that you need to appear, right? Defendant's notice would be given that you need to appear on so and so that plaintiff also may be informed that yes, this is the date we are fixing as per the request made by you by way of submitting an application. And if court has already given the notice that on 15th of February, you need to appear before the new court, where in such cases, the new court do not need to again issue summons and inform the defendant that you come appear before it. If the date is same, if the date is still 15th of February only, the new court need not inform. But because of any reason, if new court is making any changes, it may inform that it was proposed as 15th, but you need to actually come before the court on 28th of February. Because on that day, we are asking you for appearance. So unless and until date is changed, notice is not needed, summons need not be issued to the defendant because that is understood. Previous court has already informed that. Notice shall be deemed to be a summons for appearance of the party. Whatever notice was shared by the previous court, that itself would act like a summons for appearance because based on that ground only it was requested for. Where an application is made by the plaintiff requesting for these things, the plaintiff shall not be entitled to an appeal against the order returning the plaint. When court took a decision that we are not the right court having jurisdiction to try this matter, plaintiff only came forward and said, right, that okay, fine, if you are returning, also return, no problem, but fix this date, inform the defendant also. He only had made an application. So it's like impliedly he agreed to the order given by this previous court, right? So that's the reason why he will not be entitled to appeal. He cannot file an appeal because he only has indirectly given acceptance by way of submitting this application requesting for these three things. So in such case, his right to appeal would not be there. He cannot appeal. He need to present before that so and so concerned court. 10 is talking about just return of plaint, and 10A is that court is having this thing, right, to fix a date for appearance. And if they are doing so, it's not necessary for the new court where the case is being filed. They don't need to issue summons and everything. So it's just like the procedural part, what would happen in the new court and what has happened in the previous court where at first case was being instituted. We have one more provision in this return of plaint, that is section 10B, like rule 10B, that talks about power of appellate court to transfer suit to the proper court. So where an appeal against an order for return of plaint is being filed, as in the person has not submitted this application which is being mentioned. The plaintiff did not decide to file an application, but rather he decided to go for an appeal. So where an appeal against an order for return of plaint is being filed, the appellate court, which is hearing the appeal, confirms such order. Appellate court is also like, yes, this order that the certain court has passed is right only. They don't have jurisdiction to try the matter, so they decided to return it. So if they confirm such an order, the Court of Appeal may, if the plaintiff by an application so desires, while returning the plaint, direct the plaintiff to file the plaint subject to provisions of Limitation Act in the court in which the suit should have been instituted. So the right court where the case should have been instituted, considering the jurisdiction and other things, it may be mentioned as well. And fix a date for appearance of the parties in the court in which the plaint is directed to be filed. And when the date is so fixed, it is not necessary for the court in which plaint is filed to serve a notice. If the appellate court has already fixed a date for appearance of parties, that itself would act like the summons need not be issued by the new court because already notice was been served to the persons. So serve the defendant with summons for appearance to the suit is not necessary, unless that date is being changed. So if appellate court has mentioned 15th of February, but then the new court has changed the date to 28th of February, in such cases, they would issue summons. Otherwise, if it's the same date, then summons would not be necessary in this case. The direction made by the court under the subclause 1 shall be without any prejudice to the rights of parties to question the jurisdiction of the court in which the plaint is filed to try the suit. So that is related to appeal part. If party has appealed, this is if party decided not to appeal and rather they have submitted an application, what will be the procedure? And this is simply on return of plaint. Okay, so there was one case related to this, ONGC versus Modern Construction Company. It was filed as a civil appeal before Supreme Court of India, wherein Supreme Court held that when a plaint is filed in the proper court, after getting returned from the wrong court, it cannot be said to be a continuation of the same suit. It is not like continuation of the previous suit, but the suit must be deemed to commence when the plaint is filed in the proper court, because anyways, previous court itself was not proper. So we would not say that it started from that point in time. But when in the new court case was instituted, that would be counted as continuation of the suit. Okay, so this is with regard to the particulars of plaint as well as return of plaint.